From the Sunshine State, this is Tampa Bay's Tan Talk.
It's time for FLALAW, brought to you by the personal injury attorneys of Perenich, Caulfield, Avril Noyes. This hour will be informative, along with taking your questions and comments. Now, here are your hosts for today's show.
Good evening. It is Tuesday at 5 o'clock, and that means we are here to answer your legal questions here on FLALAW on the radio. My name is Matthew Noyes. I'm one of the partners of the law firm of Perenich, Caulfield, Avril Noyes, the oldest personal injury law firm here in Tampa Bay, and proud sponsors and presenters of FLALAW on the radio. I'm not here alone. I have my friend and my law partner as well, Lorrie Robinson, here as well. And so Lorrie and I are here to answer any questions that you may have regarding the law. As you may know from listening to us in the past, we are personal injury attorneys. That means we can answer questions regarding car accidents, trip and falls, slip and falls, malpractice, work injuries, workers' compensation claims, and even Social Security disability matters. We'll be touching base on a few of those, but we welcome you to give us a call or contact us with any questions that you have. There are 3 ways to contact us for the next hour. The first way is the easy way. Just give us a call at 727-441-3000. Or you can jump on our Facebook Live page. You can see Lorrie and myself here in the studios. And that page is Perenich, Caulfield, Avril Noyes Injury Lawyers. Perenich is spelled P-E-R-E-N-I-C-H. And there's one third way to do it, and that is jumping on our YouTube channel. We are also live on YouTube right now. And so you can see us, and you can type in your questions, and Ed on the other side of the glass will be giving us your questions over to us, and we're happy to address those questions as well. I may sound a little different because I may still be on island time. My wife and I came back from Margaritaville of the Seas just this morning after a fun little getaway with some dear friends of ourselves. And so we got off the boat at 9 o'clock. I was in the office at about 11:30, and now we're here on the radio. So I'm still on island time looking for the casino and the buffet. But Lorrie and I are here. Lorrie, thank you for helping me out today. As I said, my stomach was growling because I'm used to eating 24 hours a day.
Very, very happy to help out. I don't think you're going to find the buffet here.
I'm looking. But Lorrie, thank you very much. Why don't you tell our listeners, although you've been on here many times before, why don't you tell them just a little bit about yourself and about the firm in general?
Sure. Well, I'm a Clearwater native, and I've had the great blessing to be with our law firm. This is actually the 27th year. I can't even believe that's true.
Yeah.
And I've actually been practicing quite a bit longer than that. Yeah. But one of the things that's very exciting is that when I came to the law firm in 1998, I was an experienced civil trial lawyer. I'd practiced down in West Palm Beach for quite a number of years after I graduated law school. But then I came back to help my mom, who was having some various issues at that time. And as a result of joining the firm, I was able to complete the requirements to become a board certified civil trial lawyer, which from the time I was 12, my great dream was to be a trial lawyer. That was always what I wanted to do. And I was able to complete the requirements for that at the firm with quite a number of trials in those early years.
And that's a distinction that most attorneys can't affect. 98% of the attorneys can't say that they're board certified.
That is true, because it does require demonstrating a particular level of trial experience. You take a test and that kind of thing. But the truth is, and what I've learned over the years, I'm so grateful for all the experience I've had. So many cases don't end up going to trial these days. And so it can be kind of difficult to achieve that experience. So I'm grateful to have it so that, if we have a need to go to trial, we're in the position to do so. And actually, we're always looking for that opportunity.
That's right. But I think the insurance companies has a list of law firms that will take the case all the way to trial and those who won't. And they'll be a little harder to negotiate settlements with those who won't take it to trial.
It does turn out, like in all things in life, you've got to be in a position to say no credibly, to the offer the insurance company gives you in this kind of a context. And I do think you're right about that. I think that because our law firm always has had that reputation for being willing to try a case if it needed to be tried and to do a very good job, I think that helps us a lot in getting the best result for our clients.
And that's partially what we tell our clients, right? When we're about to file the lawsuit, we always have a discussion with the clients before we file the lawsuit and saying, okay, we have to be committed to filing. We're committed. You have to be committed too, because it doesn't do any good to file the lawsuit and then 6 months later have the client say, okay, I'm just going to settle for whatever they had.
Right. And it is difficult, obviously, for a person going through the process because, unfortunately, the legal process can take quite a lot of time.
Right.
And that can kind of wear people down, and the insurance companies kind of play on that. But in the long run, most people don't really want to go to trial. And actually, if you, other than now as a lawyer, it's a little different, but if you as a person want to go to trial, you probably don't actually appreciate.
It's probably not the right reason.
No, but you still need to be willing to.
Right.
So
that's 100% true. And I always say that we're the captain of the boat, but they're the boat owner.
Yes.
If they tell us to steer towards the rocks, we'll say, no, you don't want to do that. But if they tell us to still steer to it, we'll try to always tell them not to do it. But ultimately, if they want to end up settling the case, we'll do what they wish us to do.
Yes, because it is, if you have the, I'm going to say misfortune, because obviously no one wants to be the subject of an injury for any circumstance, but certainly not when it's been as a result of somebody else's negligence. That makes it seem all the worse because it was something that really didn't have to happen, if people have been exercising more care. So it's very, very difficult, but lawyers advise. So we're going to give you, as the client, the benefit of our experience and our legal knowledge, but it is your case.
Right.
If it's, and it's very important. One of the things that's so hard is that over time, you'll talk to people, clients, and maybe they've had some other attorney at some other point, and then they had another claim, and they really regret how the case was handled. And, it's hard for us to know details on something that was handled by somebody else, obviously. But one thing I try to do, and I know you do as well, we want to help the client to come to a decision that they have a full understanding of and that they have a comfort level with, so that you don't spend the rest of your life saying, oh, my goodness, if only I'd done this, that, or the other.
Right. There's a song called "What If." And you don't want any what ifs. And I think that's part of our job as their counselor, as their advisor, as their attorney, is to, talk about the what ifs, let them know what they could be, and then ultimately guide them through their decision.
Right. That's at some point in my career, you're attorney and counselor at law, and that counselor at law is perhaps the major part of it in many respects. Really.
And it's we talk about this all the time. That's not what they teach you in law school.
No.
They don't teach you how to run a business, and they don't teach you how to be a counselor of law.
Not at all. It's really all, taking tests and book knowledge, which.
Yeah, critical thinking. I mean, it's very good.
Yeah,
right. It is good to help us think and do logic.
Yeah, you have to have that foundation for sure. Yeah.
Yes. Well, one of the things we were talking about is the car accidents, and there are negligence that happens, and sometimes car accidents just happen because somebody wasn't paying attention. I was talking to a very nice family this morning whose son got rear-ended, and mom was mad at the at-fault driver, and dad and the son were a little more. It's an accident, but sometimes it's more than just negligence. It's almost carelessness when you get behind the wheel and you drive after you have had too many alcoholic beverages. And the 4th of July just passed.
Right.
And
hard to believe. My goodness, this part of the year.
And unfortunately, the national data showed that about 437 motor vehicle deaths occurred nationally during the three-day Independence Day holiday period. And about 38% of those involved alcohol-impaired drivers. I tried to look to see how many were in Tampa and such like that, and they didn't have those numbers just yet. but the DUI task force, they had a coordinated DUI operation in Tampa Bay, Hillsborough County. And it was through July 4th through Sunday, resulted in 45 DUI arrests. Not accidents, but arrests. So hopefully they prevented 45. And then, but unfortunately there was too many accidents as well.
Right. And
So-
it's so easy for people to, obviously take a chance where they really shouldn't.
Right.
So I think because that's probably those roadblocks are where they set up so that they
Right.
be able to pull people over. And it's the 4th of July is a great weekend. We have all wonderful holiday weekends, obviously, and weekends in general are very nice.
Right.
But it is something people need to be very, very cautious about because obviously the worst thing in the world is to have an accident in which somebody's seriously injured that happened because you were foolish
Right.
and allowed yourself to be driving when you really were under the influence and should not have been.
Right. And are there other types of benefits, or not benefits, but damages that could be pursued against somebody that was arrested for DUI that caused injury to you?
Yes. And we can talk a little bit about that. So often, so there is a type of damage called punitive damages, which is a damage intended to punish truly egregious conduct with a large financial award. It rarely is something that comes into play, though.
Right. And people think, we eat, sleep, and drink this
Right.
stuff, but typically the average Joe doesn't appreciate how hard it is to prove punitive damages. And you can't file for punitive damages without a proffer of evidence.
Right. And it has to be something that goes beyond a normal level. If you want to, it's the wrong word to use, normal level of negligence, but it's really got to be something truly egregious. And a part of the other thing people don't realize very often, this is kind of a classic situation when if someone rear-ended you or otherwise you were in a bad accident and the person was intoxicated that caused the accident, that's infuriating. I mean, it would always be infuriating to be in any kind of an accident, but particularly when something like that, again, it should not have happened. But in reality, even if you were able to pursue a claim for punitive damages because the particular facts were somehow unusually egregious. So we can imagine, someone that was repeatedly had multiple DUIs, or you could create a set of facts where the person knew what they were doing. It wasn't like you just went to a party and you made a mistake and had one or two more than you thought or should have, type thing. But say you get an award for punitive damages, you're allowed to bring the claim or something. Well, insurance is not going to pay for a punitive damage award.
Right. The at-fault driver could have $1 million worth of coverage, but none of that coverage would go towards that punitive damage claim.
So you could only really bring a claim like that against a party that actually had a lot of collectible assets, meaning, that they have enough financial resources that are not protected in various ways, which most resources with people that have a lot of resources are protected from being very easy to actually secure a judgment and collect from people. And the other aspect of it is really honestly what drives jury awards that are large to begin with are things that would tend to make people upset. And so in that scenario, there is a way through the pain and suffering and the other elements that can come through, except that in most instances, if a driver has caused an accident and they were intoxicated, they were DUI, in most instances, that's going to be a situation where liability will be admitted so as to prevent the jury from hearing anything about that, because everybody obviously would be outraged by any accident that occurs because somebody has had too much to drink.
Sure. And then, Lorrie, what happens when we talked about this DUI at-fault driver and his insurance company doesn't have to pay for the punitive damages aspect? But there's other scenarios that we have that even if it's not a DUI driver and that person does not have any bodily injury liability insurance, can somebody who gets injured by an uninsured at-fault driver still bring a claim against that driver?
And so the answer is yes, but the part that people don't appreciate is much as we harp on the insurance companies, and we do all the time.
We do. well-deserved harping, though, I
yes,
must say.
yeah, I would say so, obviously. But the reality is you can sue a person for negligence and for harming you as a result of negligence, and you can get a big judgment. But if that person doesn't have the financial resources to pay that judgment, then you've got a piece of paper.
You got a piece of paper that you probably spent about $10,000 in cost, because you'd have to take that case all the way to a jury trial.
Right. The costs are very significant. So you will not find many cases being brought where there isn't a defendant that's collectible or there isn't insurance. So it's kind of difficult because people don't really realize that. So, your question is, well, can you sue the person? Yes, you can. But if you don't have the type of insurance that we talk about every opportunity, the uninsured motorist coverage,
100%.
That is a policy you buy, but it protects you from being injured in an automobile accident in which the other driver either didn't have any liability insurance or had inadequate liability insurance for what happened, which, there are no requirements, there are very minimal requirements, as we always talk about, for what's required to get your driver's license and get in that car. It doesn't actually even require that a person have liability insurance for having caused bodily injury to somebody,
Right.
Which is amazing.
It is amazing.
But it does not really require that. It requires only liability insurance for property damage, and it's limited, for cars, the damage that might occur. And it requires that personal injury protection that we also talk about, which is for your medical expenses, basically if you are in an automobile accident. So people don't really understand their coverage usually until they go through an accident, and then you find out, what the situation is.
There's too many times that we sit and talk to people that got injured in an automobile accident. We look at their declaration page or their insurance coverage, and we see that they have lots of bodily injury liability coverage, but they reject uninsured motorist coverage. And so we always have to have a discussion with them saying, listen, you spend all your money to protect everybody out on the world from your driving, but you spend zero money to protect you and your family from everybody else's driving.
And it's the kind of thing I think occurs to me to talk about the importance of being an informed consumer, because a lot of times what happens, you go to an insurance agent, they are really not that focused on that issue.
Right.
The actual amount that it costs to add uninsured motorists to your coverage is not that huge. Everybody has to obviously look at their own situation, but it's not really that huge. But there's no real incentive for the insurance agent to talk about it. And that can be true in a lot of different contexts. Like I know we just recently had a case that finally, after so many years, we were able to draw to a successful settlement where a gentleman had, it was not an auto accident, but it was an accident involving a home. And the gentleman had homeowner's insurance, and he had what we call an umbrella insurance policy, which kind of stacks on top of your homeowner's insurance, and people would be kind of familiar with that. It's usually adds like $1 million on top, so you're totally covered. But this gentleman found out, and we found out in representing our client, that he did not have the insurance he thought he had.
Right.
Because he was required to have $300,000 for homeowner's insurance, and he only had $100,000, which, just like anyone, if you're not a lawyer looking at this stuff, you're not really going to be that tuned into all of that. So, and yet it's important. So when you have insurance coverages that you're considering, and each time you renew them, you really ought to be looking at it pretty carefully. And if you don't know precisely why you have what you have, you ought to review it with somebody that does.
Yeah, and our office is always happy to review your your car insurance policy for you. We'll give you advice on what you have and what you don't have, and make recommendations for you, because I think that's important. Our job is to protect somebody even before they get involved in an accident.
And if you're gonna pay a significant amount of money for your insurance premiums, which you do, really, you want to be sure that you are getting what you actually need.
Yeah, and you're protecting you and your family.
Right.
And sadly, nowadays, it's so often done just on the computer.
Yes.
And it's a sign now, click here, be done. And in order to not have uninsured motorist coverage, you have to actually reject uninsured motorist. There's a form that it's a rejection of uninsured motorist coverage, but nowadays with the sign now, it just drops you all the way down to the signature page. And unless you scroll up to see what you're really signing, you may not appreciate that you're rejecting the most important insurance coverage, and that's the uninsured motorist
Right.
coverage.
So it's something makes it even a little harder really
Yeah.
to know what you're getting, because you really got to know in advance.
Yes. And look at your policy now before a car accident to make sure you have what you think you have. I mean, we always hear,
Yes.
I got full coverage. I have full coverage. Well, full coverage doesn't mean anything.
No, actually, when the person says they have full coverage, we know.
It scares me.
Yeah.
It
And
does.
most likely they have that very bare minimum that I mentioned just a moment ago, which actually doesn't protect you in any circumstance.
Right.
I mean, yeah.
Now, bodily injury liability coverage in 99% of the times is not required in the state of Florida. However, if you're Uber or you're Lyft, there is a law in Florida and it really protects other people, especially the passengers of Uber and Lyft drivers. The law, although we don't have the average personal driver is not required to carry bodily injury liability coverage. Ride sharing, such as Uber, Lyft, and those other places, the statute does require them to have bodily injury liability coverage, which makes sense.
It sure does.
Yeah, but can you explain to our listeners, what type of bodily injury liability coverage is now required for people that are having Uber and Lyft?
Right. So it's kind of complicated, and there are kind of several different scenarios, but I think probably, like taxi cabs have liability insurance. There are requirements, and thank goodness there are. And now with Uber and Lyft, where there's all these people,
All those people
that are doing this.
I know. I was at the Morgan Wallen concert in Houston with my son, and there were probably 200 people waiting for Uber Lyft.
And as many people know, probably some people listening are actually Uber drivers or Lyft drivers, because it's a great way to pick up some extra money, or even, actually have that be your main vocation. But so the laws have been passed to try to basically protect the passenger in those situations. So you have different situations. Like I think probably the most important thing for us to start with is that the person that's the Uber driver or the Lyft driver, their personal insurance is not likely going to cover them because
exactly true.
They're in business.
Right.
Okay. So
and there's exclusions right there in their policy that says if you're doing ride sharing at the time, we're not covering you.
Right. So that's not where you're going to get protection. So the law has stepped in, and as a result, Uber and Lyft and these kind of companies will have insurance coverage available to their drivers. So
and really, there's two phases, kind of so to speak, for that bodily injury liability coverage. One, when the driver has the app on, but he hasn't, or he's en route to pick up. But no ride has been accepted just yet. App is on, he's waiting, and he causes a crash.
Right. And so I guess that's kind of interesting. Normally the cases we see are typically when the person has a passenger, because likely that passenger has come to us for representation.
Right.
So that's probably the usual situation. But I guess it makes sense that you could have the two phases where they've required less insurance. So if the person is just, it's the Uber driver, the Lyft driver, but they haven't got anybody else in the car yet, then the coverage requirements are $50,000 per person, and then $100 total,
per
kind
accident,
of thing.
yeah.
So it's and that's kind of a sort of a standard low but decent
Right.
policy, basically. But then if if a ride's been accepted, and I mean, obviously we have had so many cases. I mean, I'm not against Uber or Lyft. Everybody loves it. But honestly, maybe because there are so many drivers out there. So of course we're going to see accidents.
Because of the ride sharing, I think there's just, I hate to call it opportunity, but more chances of a car accident because there's more cars out there
that are within this offering this service. So in that scenario, if it's a scenario where the Uber or Lyft driver is actually transporting someone that has a passenger, then the liability is $1 million in coverage. So there's never an issue about coverage there.
Right. It's also if they're just en route to pick up the passenger.
Okay.
And that there's $1 million worth of coverage.
So if they're actually out doing what they do, great. But if they're just sitting somewhere or have not or are not en route to a passenger, then it's the lower coverage. So the more normal thing we do see is if somebody's been injured in an Uber or Lyft, the coverage is not the issue. There's plenty of coverage.
But it's I hear some clients say, listen, I was in an Uber. I know that they're required to have this bodily injury liability coverage, and I was in an accident with the driver. But it turns out the Uber driver wasn't at fault. It was the other car. So all this bodily injury liability coverage doesn't come into play when the Uber driver is not at fault.
Yes.
It's only when the Uber driver causes the crash.
Well, and it would, of course, kind of make sense because the platforms, Uber and Lyft, they're protecting from their drivers negligence, basically. And it kicks in again. That's why you need to have uninsured motorists if you own a vehicle. So that you have something, because if you are in a situation where in an accident, Uber driver didn't do anything wrong, it's the other driver, the other car, and they have limited or no insurance, no liability insurance. Now, if you own a vehicle and you have uninsured motorist, you will have coverage,
even if you weren't in your car.
That's right. So I think it's a kind of complicated area for people. I'm sure that people's, when they hear this, they probably don't even listen because they're like, you guys are always saying this.
Yes, but
that's why.
If you are in an Uber, if you're involved in a crash and you're in an Uber vehicle, it's important to talk to an attorney to know what your rights are.
Oh, sure.
And to investigate the accident to see who caused the crash and stuff like that. There's never an easy answer when there's a car accident.
No.
But with an Uber accident, you may never appreciate that your automobile insurance would cover your claim, even though you weren't in your auto accident. So, listeners, my name is Matthew Noyes, and that's Lorrie Robinson. We are here live on FLA Law on the radio right now. There are three ways, again, if you're just tuning in, there are three ways to get your question over to us. One way is to call us at 727-441-3000. Or you can jump on our Facebook page. We are Facebook Live right now at Perenich, Caulfield, Avril Noyes Injury Lawyers. That's our Facebook page. And that is also our YouTube channel. You can jump on YouTube as well. Watch us in the studio and send your questions through YouTube. And Ed will send us your questions right over to us. So there's three ways to contact us in the next, little about a half hour.
There you go.
And if you can't contact us or you want to listen to a prior episode, every week we upload our show to the podcast. We have it on Spotify, we have it on Apple Podcasts, and we have it on other platforms for podcasts as well. So if you want to get back to another episode, you can just jump and find FLA Law on the radio on your favorite podcast platform, and you will have access to all of our episodes over the last, I think it's probably over the last year, that's up there now. So again, but if you have questions now, give us a call now when you can get your question asked. Lorrie and I have been talking about auto accidents and in Florida. I mean, driving down here from the office to the radio station, there was so much traffic.
Yes.
It was crazy. And it's not even that time of the year, I don't think. So, but it was crazy. So car accidents happen too often. We all know that. People aren't paying attention enough, way too often. But sometimes car accidents occur and both parties may be at fault for a certain degree. The law recently changed. Florida laws recently changed as to the comparative fault system. Lorrie, can you explain to our listeners just a little bit about what it was and what it is now when comparative negligence comes into play?
So all the long years of being a lawyer, I remember when I went to law school, they talked about the, contributory fault and all this. And there used to be a very, we would say, quite draconian system where if you were at fault at all as a person injured, forget it. You couldn't make a claim. But then most of the time over the last long period of time, 30, 40 years, and even longer than that, if if you were somewhat negligent yourself, arguably, so say there are lots of situations like, say, you're making a left turn, at an intersection, and arguably you turn in front of somebody, or you're going a little too fast. So they say, you say no,
Right.
whatever it is. But say there's, a way you could look at it and say that maybe a little bit of fault here and a little bit of fault of the other car. Well, it used to be that the jury would just sort that out. So maybe they said you were 60% at fault, and the other driver was 40% at fault. Well, then what would happen? Your award would be reduced by the percentage of fault that had been attributed to you. Now, the last change in the legislature, what they've changed, and it makes it very difficult, is that now if you are 51% if you're more than 50% responsible, the jury decides for the accident, no recovery at all, period.
Yeah.
And of course, you think about that. How do you decide 50, 50, 51, 49? It's crazy. I mean, you can, particularly in situations where there might be an area where, there's some degree of comparative fault, as they say. But this is a pretty tough system. And this applies now to auto accidents, to trip and fall.
I was going to talk about the slip and falls. They could have a puddle at Walmart or any other, I shouldn't have said Walmart, but any of those stores. And they could have the puddle there. It could be there for an extended period of time, and somebody slip and fall on it. And a jury could say, you should have watched where you were walking, or the store did not know that the puddle was there long enough. And say you're 50-50. Well, if you're 50-50, then Walmart would have to pay 50% of the damages. However, if they say you're 55 and Walmart is 45, and let's say the damages are 100,000, just
make
because
it simple.
I can do math easier that way, although it's still an island time. But let's say it's $100,000 worth of damages. Well, if you're 50% and the establishment's 50%, the jury would award $50,000, 50%. If you were 40% and the establishment was 60%, the jury would come back at $60,000. But for some reason, if you were 55% and the establishment was 45%, the jury comes back with zero.
Right.
And it just doesn't seem fair.
It really isn't, because it's very difficult. You think about that. I mean, what actually happens in a jury deliberation in situations like that is kind of a compromise. Usually, they're trying to come to some sort of a unanimous conclusion. And so if you have a situation where there's substantial fault on the part of, say, the establishment, it does seem unjust for there to be no recovery, because there's a significant component of fault. Now, maybe if they'd said, look, if there's only, I'm going to make it up, 10%, something like that, if they'd said some limited part, even then I think that still should be apportioned to the person that is responsible for that, or the company, whatever it is. But that would be more defensible to me than taking a situation, which the legislature has now, where they have created a circumstance where there can be substantial fault on the part of another person or company that actually will go completely unaccounted for.
Right.
And that is unfortunate.
And we started the show talking about punitive damages, but really for most of our cases, we're not talking about punitive damages. We're just talking about holding people accountable to just the extent of their negligence.
Right.
And so it just doesn't seem fair, doesn't seem right, that if we're trying to hold people accountable and a jury said that they were 45% responsible, why does the law say that they don't have to pay anything?
And, when you, on the surface, you can understand how maybe people could argue in favor of, well, wait a minute, because you were more responsible than the people you sued for this, and so you got to take responsibility for yourself. But the reality of life is, and how these things would be looked at, I mean, how you establish a percentage, so particularly in these areas where we're kind of in the mid-range, is, I think it's just not it's not really looking at what the reality is of what happens in a particular situation. Most people will think a person should obviously take care for where they walk, et cetera. And we don't disagree with that. But in real life, if there's significant issues with a condition that's created or allowed to exist for a significant period of time that cause injury, it just, our tort system has always been there so that people could make some sort of a financial recovery for their damages. But I want to add one other thing, which is you should not decide in your own mind how you think a jury might determine those percentages, because I've found over time, now sometimes people are unrealistic and they think they had no role in it whatsoever. But I would say more times than not, most of us are pretty hard on ourselves,
right?
And we'll think, oh, I should have seen that, whatever. And so that's the kind of thing that should be reviewed with attorneys that handle these kind of matters, basically, because these percentages are anything but exact. There's obviously no book one goes to decide in an individual case how things should be apportioned.
Yeah, and that's why it's always important to talk to an attorney after you get hurt, whether it is a car accident or a trip and fall or slip and fall. Talk to an attorney. Doesn't mean you have to retain the attorney, but talk to the attorney. That we give free consultations, and I think everybody else gives free consultations as well.
Pretty much in these areas, yeah. So
utilize that.
And particularly now that the statute of limitations is quite short comparatively. It was reduced from 4 years to 2 years from the time that you were injured. And a lot of times people will think, well, I'm not the sort of person that would bring a lawsuit or anything. I'm not that sort of person. But if you've had a significant injury that continues to nag you and bother you, do you really want to spend the rest of your life feeling that you had something happen that was unjust and then you just kind of let it slide?
Okay. That's that what if again.
Right. Yeah.
So you have to avoid those what ifs, resolve those what ifs. And so.
Right. And you come talk to a lawyer, they review it. If it's something that actually probably wouldn't be successful to pursue, you find that out. Now you've at least checked it out. But on the other hand, if you find out, no, the lawyer does think that this is something that could be successfully pursued and should be pursued.
Right. Just today, I had two conferences with potential new clients, and one of them was hoping that their injuries from the car accident would subside after a short period of time, and was hoping that they didn't have to bring a claim. We talked about PIP and all that, and we all decided that it may be best to wait for a month to see how your pain heals. He's a young guy. He was hoping that his pain would subside. I said, that's fine. Here's all the legal information, all you need to know. And let's hope it does. Let's hope it does subside and you don't need to bring a claim.
Right.
That's the best case scenario.
Exactly.
And then the other one was a workers' comp claim. It was a pretty recent workers' comp claim. And when he first called, workers' comp wasn't providing them the workers' comp benefits. But after the time period elapsed a little bit, workers' comp was starting to provide the benefits. So my advice to him was, here's what to expect. And if workers' comp does not provide you with the benefit, let me know. But in the meantime, you don't need me just yet.
Right.
But it gave them both the opportunity to understand what their rights and what their responsibilities are. And I think that's important.
I think it's very important. So the person does know a little bit, at least, about what their rights would be, what to expect.
Otherwise, they're relying on the insurance adjuster. And you don't want to do that in any situation.
No.
Okay, we're gonna make a shift, Lorrie. We got about 15 more minutes left in the show. We're gonna shift away from auto accidents and negligence claim and into another area of law that you and I handle a lot with, and that's Social Security, disability, and Social Security, other Social Security claims. And so we started doing that because we saw so many people really suffering. And so I think we've been doing it now for 10 years, probably a little longer than 10, or longer than that.
Like 20 at this point. That's the way time goes.
I know, it flies by. And we've helped many well-deserving people obtain the Social Security benefits that they earned.
Right.
And I think one of the biggest myths about Social Security disability is that it's kind of a handout. Can you explain to our listeners, why Social Security, what the big myth is, why Social Security really
actually,
isn't.
Many people don't. They think it's a separate type of benefit that just is out there that the government will give you a benefit for disability, and that would be sort of like you say, a handout or a welfare type benefit. There actually are two Social Security benefits. One of them is called Social Security disability income, and that type of a benefit is based on what you've paid into the Social Security system. So it comes from what you're paying in, so that you will have retirement when you get full retirement age, currently 67. You can take it early at 62 at a reduced amount for your Social Security retirement based on what you've paid into the Social Security system through taxes. Your employer matches that, but you've paid into it's yours.
Right.
And in that situation, if a person has a medical condition or a mental condition that prevents them from working out to their full retirement age, then they can get disability. And that disability, you're really in fact getting your retirement early based on your
inability to work.
Right. So that's what it's called. Now, there is a type of Social Security disability called SSI, which is Social Security supplemental income, something like that. We call it SSI, but they've got abbreviations for everything, acronyms for everything, and that's like whatever. But the SSI is a welfare program. So sometimes people have not paid into the Social Security system long enough, and this happens more than one would think. A lot of times people that you might have worked for quite a number of years, and then maybe you stopped working. Could have been like sometimes women will be raising the kids or whatever, but it might also have been whatever the reason is, might even be that you do have a medical disability and you just stop working because you can't really, and you don't realize that you could apply for disability, and you let a little too much time go by. And so if there's 5 years from the last time you really worked steadily paying into the system, then in that situation, your work credits aren't recent enough for a disability application. They're fine for your Social Security retirement at your full retirement age, but they aren't recent enough. So that's a situation where you wouldn't qualify for the disability that's based on your own earnings, but you might, if you are impoverished, you could possibly qualify for the SSI, which is a small payment for people that really, they basically have no resources. You can't have more than a couple $1,000s in the bank at most, and that kind of thing. But if you're, in a situation where you can't work, you have these medical issues, and that, and that's a benefit that you qualify for, then we're here to help people in those situations.
Right. And the most important thing I think people have to appreciate is you have to prove that you're disabled.
Yes, I would say, a lot of times people will come in and they'll say, well, I know I qualify. I looked up on the internet, the web, and I found I have this condition, this condition, this condition. And most people will start out by giving you a long list of the medical diagnoses that they have. And it may sound pretty bad, and it may be pretty bad, but it's not that, because Social Security is looking at what your limitations are. So what can you still do physically? What are your limitations? What do they allow you to do, even given all of the problems that you have? And that must be medically documented. It is not enough to tell Social Security, how you feel and why you can't work. It's not enough that you had, a lot of times we'll have a situation where somebody, maybe they have major back issues and they've treated extensively, but it was years ago.
Right.
And the reason they stopped is because it wasn't helping. So they stopped. Well, now you without a fresh record with orthopedists and other doctors related to your back condition, there's nothing that medically documents that you have significant limitations in what you can do as a result of these medical conditions. And so that is the biggest mistake people make. And then, of course, if you don't have insurance, obviously it's very difficult. But you can get medical attention through the Pinellas County Health Department. It does require a lot of persistence,
right?
Obviously, and it's unfortunate.
Patience and persistence.
It does, and it's and when you don't feel well, it's kind of hard to summon up the energy to do it, but you have to, because
and one of the other things that we see a lot is, well, not a lot, but we do see a doctor's note saying patient is 100% disabled.
Right. And people.
What does that mean?
Yeah.
I mean, does that help? Is that helpful?
No, oddly, I don't know if it's unhelpful, but it's not helpful because
Right.
what ends up happening.
It's not conclusive, that's for sure.
Yeah, the Social Security, it's like almost like a red flag. The judge, if you're in front of the judge in a hearing, they'll always say, well, that's for Social Security to decide because the law is they determine disability. And so what they really need to see from your doctor is what your limitations are. So if you are unable to lift more than 10 pounds, maybe you can't lift more than your gallon of milk and you can't do that very much. You need to be talking to your doctor about that. If you can't sit for more than 15 or 20 minutes, if you have to lay down to recover from the back pain from sitting and whatever it is.
What consequences you have from the medication.
Right.
And
if
such
there's some
like that.
issues there, those are the things you should talk with your doctor about. The doctor can then address those things. And if they can help, fantastic. That's better than any Social Security claim. But if they can't, now your limitations are documented, and that's what Social Security looks at. Now, if your doctor then signs off on a form that we prepare or prepares even a short note that says the person has these limitations, this is why I think that they are unable to work. It's these limitations. Social Security will not look at the doctor's opinion about work, but they will look at the doctor's opinion on the limitations you have. And if those things are the kinds of things that would interfere with a person's ability to work, then that's extremely helpful because that's actually what Social Security bases a decision on.
Exactly. And what I hear a lot, and they ask me, they say, Matt, what's the worst thing I can do that can really defeat my Social Security case? And it's really the lack of treatment. If you
Yes.
stop treating, it's almost impossible to win a Social Security disability case.
Yeah, Social Security will send you to one of their doctors if there's no recent medical treatment, but
it's one of their doctors.
and the doctor's paid very little and obviously isn't your doctor. So they see you for a short period of time. There's no way, unless you have something, so obvious, which you don't, nobody does really. I mean, unless it's like if you're paraplegic or something, there would have to be something that is just completely, no doctor could fail to diagnose it. But in your situation, in most situations, particularly what we see, you'll obviously see a lot. We see a lot of cases that are chronic neck or back pain or things of that nature.
Anxiety, depression,
right?
And all that.
And all of those kind of things, it's going to depend because in many instances, our clients will have worked for a long time with those conditions, but then they reach a point that it is so bad they really can't.
Right.
So you have to have. But no doctor you see one time that is not your doctor can offer any opinion on that that's going to be helpful. So it really becomes kind of like a paper thing. I mean, occasionally those evaluations will be helpful, but it's very, very unusual that they would be.
Yeah. And one thing we hear from our clients also is, oh, Lorrie, it takes so long in order to get Social Security disability.
And it does.
Can you give our listeners, about how long it takes for Social Security?
Now it actually is faster than
is.
it used to be quite a few years ago because it used to take maybe 3 years. Occasionally you might have something like that now, but not too often. Now the typical time frame, if you have to go all the way through a hearing before the administrative law judge, that's going to be 18 months to 2 years typically. And that's most people's experience. There are some times when people can be approved without going through up to a hearing, but not usually. I mean, we are always happy if we're able to get a situation where we can get somebody approved earlier, and it does happen. But most people will end up having to go through a hearing in front of an administrative law judge. They do them on video. We do them out of our conference room. Works very well. And in that situation, a judge gets to see the person, hear from the person, and then put that all together with the medical record. And obviously, we're able to make presentations. And then, if you've got something that's preventing you from working, then high likelihood we'll be able to get you approved at that point. But unfortunately, that's the usual situation. Even if you have a situation where you don't end up having to go to a hearing, the initial application process takes 6-8 months, a year, usually.
Yeah, there's. I did a little research, and according to Social Security, they say from the time that you file to the time that your application is decided, they put it in days, 229.9 days for 2025.
Okay.
That's 7.5 months before you get your initial response
Right. Oh,
to the
that would be
application.
consistent with
Yeah.
our experience, I would
Yeah.
say. Sometimes
That's
it's
a little
longer.
Yeah, I mean, that's a little better than last year,
Mhm.
but not a lot better than last year, only by a few days,
Yes.
quite
No.
honestly. But what is faster now? What is faster now is the fact that the hearing time,
Yeah. Hearing
from
time.
requesting hearing to getting the
Yeah.
hearing,
Once
is
you get
different.
to that point, within 6 to 8 months, we're before the judge. But that's the end of the process. So it's best for people to just understand if it goes quicker, great, but you just have to be prepared that it's going to be a longer process.
And if someone's denied disability, is hiring an attorney worth it?
Oh yes, I've
Why?
been a lawyer myself for this is the 46th year. Hard to believe that. It's supposed to be a process you can do on your own. I wouldn't dream of doing it
Never.
on my own.
Yes. Yes, I mean, because you don't know what the rules and
Right.
and what you have to supply to Social
And there
Security
are
and
so
such.
many of them. That's as I say, we do really mostly the personal injury, the auto accidents, medical malpractice, things of that nature. But we've done so much of the Social Security over the last number of years because people need the help. And when I saw how much is involved, the regulatory process, it's not something that I would recommend an individual try on their own without the background.
Yeah, and people get frustrated and they give up. And I think Social Security and workers' comp's the same thing. Want the people to give up because then they don't have to worry about that
So it's
application.
case management
those
for them,
benefits. That's exactly true. Lorrie, thank you. We're about to wrap this up. Another week under our belts for FLA Law on the radio. I will be back next week with a special guest to talk about probably another area of law. But Lorrie, while we may not be here 24 hours a day or 7 days a week, how can people that have questions regarding Social Security, workers' comp, car accidents, how can they reach you and me or the other attorneys of our law firm?
Right. And we encourage people to reach out to us if they have questions. That's why we do this program. And it's been the philosophy of the law firm, for 70 years, basically. So
I forgot to say happy birthday to us for 70
that's right.
years. So.
And so, you can always reach us by phone, 727-796-8282. But in our world today, a lot of people at least do things on the internet. So you can go to our website, usalaw.com or voiceoftheinjured.com. And we have all kinds of information about the attorneys, how to contact us, and I think that's a good resource for people to just get an idea about some of the areas they might wonder about.
Yeah, and if you have questions about this episode or want to send it over to somebody who may have more issues that we've talked about, jump on our Facebook or jump on our YouTube, and we'll be happy to send you over, or you can watch it, or we can be happy to send it over to you as well. Just send us an email at info@usalaw.com, and we can do that. But we're going to wrap it up for this Tuesday. I'm Matthew Noyes. That's Lorrie Robinson. And as we always like to end the show, drive safely and watch out for those who don't. Take care.